All right, thanks so much, Sierra. More than 100 sexual assault victims of Ohio State University Dr. Richard Strauss took the next step in their effort to hold the university accountable for the abuse. OSU's own investigative report revealed Strauss assaulted students under the guise of physical exams from 1979 until 1998. But after a district court tossed out the claims because they fall outside the statute of limitations, the assault survivors took what could be their final step today in a federal appeals court.
It was in April 2018 when OSU made a public announcement that it was investigating potential serial sexual abuse by Dr. Strauss that we say that's the moment. That's the moment when the plaintiffs knew or should have known that they might have a claim.
Strauss victims want to set aside the statute of limitations, claiming all those years ago they were deceived by a university that was actively working to avoid scandal and legal liability for employing a sexual predator.
There's overwhelming evidence that at very high levels this university knew about Strauss and not only did nothing about him to stop his abuse, but covered up what they did know.
The attorney for OSU doesn't deny university leaders back then shielded Strauss, but he says the students should have filed their legal claims back then because everyone knew about Strauss.
Strauss's unorthodox touching during medical exams was such common knowledge that the OSU coaching staff, trainers, and student athletes knew him as Dr. Jelly Paws, Dr. Nuts, Dr. Soft Hands, and Dr. Cough, names that reflect his sexual predation.
But the Strauss victims say no one knew then that the university was involved in a cover-up, and students who complained to coaches were warned to not make trouble. Ironically, OSU is now arguing that because coaches knew, it's further evidence that the student-athletes should have pursued justice decades ago.
Those persons were certainly in a place of responsibility and reporting and diligence. And so those persons likewise would have been at the level that they should have been informing and should have been doing what they...
Yet none of them did.
They alleged that none of them did. That's correct, Your Honor. That's the allegation in this case.
And so OSU is coming to this court hat in hand and saying, please reward us for our mendacity. Please reward us for lying and concealing and obfuscating for 40 years. Because we were so successful at lying and concealing the abuse and our response and our knowledge that we managed to get past the 2-year statute of limitations.
The 3-judge panel must now decide whether to set aside the statute of limitations and allow the case to go to trial, or whether to simply tell the victims their claims were filed too late.